using what they call Bentham's and Mill's utilitarianism in terms of jurisprudence. Listen, borrowing from Annalise Keating, this is Criminal Law 100, or how I choose to call it, How to Get Away with Murder. Now, this is jurisprudence. And in the light of Jeremy Bentham and John Stuart Mills, in terms of utilitarian school of thought, I choose to call it How to Get Away with Murder. We're going to be discussing certain moral sides of murder, presenting it as a complex and sensitive topic. In terms of morality, listen, morality varies among cultures and among different philosophies and individuals, and murder is generally considered one of the most heinous acts one can commit. So I'm going to give some moral aspects and ethical considerations surrounding murder. Now, number one, you need to comprehend and understand inherent wrongfulness in the most unethical frameworks. Taking someone's life without justification is considered inherently wrong. The sanctity of human life is a fundamental principle. Number two, this is what they call legitimate homicide. In some cases, homicide may actually be considered morally justifiable. This may include things like self-defense, defense of others, and in some contexts, war. So the moral assessment of such cases is often framed within the principles of necessity, proportionality, and even immediate threat. And then there's what we call capital punishment. The morality in terms of death, as far as penalty is concerned, is a contentious issue even for Uganda. So opponents argue that it violates the right of life and that there is a risk of executing innocent individuals. So proponents often argue that it serves as a deterrent or retribution in the case of heinous crimes. You may want to look at Susan Chigula case. And then in terms of euthanasia, or what they call assisted suicide, these principles raise what they call ethical dilemmas regarding the right to die with dignity, morality surrounding euthanasia and assisted suicide, which obviously varies across different cultures and regions and in terms of different philosophical beliefs. Then there's what we call moral relativism. In some moral philosophers would argue that the moral assessment of murder is relative to the culture and social context. What is considered murder in one culture may actually be legitimate as an act in another. And then in terms of intention versus consequences, moral assessments often distinguish between what they call intentional killing and unintentional harm. So killing with intent to cause harm is generally viewed as more morally reprehensible than unintended harm. And then there's what we call ethical frameworks. In terms of different ethical theories, such as deontology, what they call duty-based ethics, and then utilitarianism, where we're arguing that the greatest good for the greatest number and the virtue of ethics. So we shall offer certain perspectives in terms of morality as far as matter is concerned. As we will go on, there's also what I call moral responsibility. So the question of moral responsibility arises, for example, when one considering the roles of individuals in terms of society, but also institutions that have to do with preventing and addressing murder. So moral responsibility may actually extend beyond the perpetrator to those who contribute to a culture of violence or even fail to protect potential victims. Yeah? And also the impact of families in terms of communities. The moral side of murder also includes considering what they call profound impact on victims in terms of families, but also in terms of communities, and also the society as a whole. It raises questions obviously about justice, forgiveness, and also healing. Now, there's also what we argue in terms of what they call the legal system and punishment. Morality, for example, and law often intersect when it's considering how society, for example, responds to murder through what they call legal systems and punitive measures. So the moral basis of legal punishment therefore becomes an area of ongoing debate. Now, as we'll continue discussing, we're going to comprehend very interesting cases. So in the essence of morality of murder, it becomes a multifaceted and even deeply philosophical topic. It touches upon what they call fundamental questions about human rights, about justice, about ethics, and about cultural norms. It's also a topic, for example, where moral views can actually be, viewed widely, making it important to engage in open and even respectful dialogue when discussing these complex ethical issues. Another complex issue we may want to talk about is rehabilitation and redemption. Some ethical perspectives obviously emphasize the potential for rehabilitation and redemption, even those who have actually committed murder. So they argue that society should actually provide what they call opportunities for individuals to reform and even reintegrate in the community. Yeah, obviously the aspect of retribution of an eye for an eye, which was propounded early enough, retribution of justice based on the principle of an eye for an eye holds that punishment should actually be proportionate to the harm inflicted. So moral debates continue over whether this principle is just a way to address murder. I think Mahatma Gandhi, if we address an eye for an eye, then the whole world will go blind. Now there's also what they call moral ambiguity. In some situations, such as cases of self-defense or even just war, we present what they call a moral ambiguity when determining the morality of killing. So these scenarios can actually challenge conventional moral assessments. And then when you argue it in terms of what they call psychological and societal factors, then the moral side of murder may also involve considering the role of psychological and even societal factors in the commission of violent acts. Now, so issues like, for example, mental illness, environmental influences, and even social support structures may actually play a very crucial part in these moral considerations. Now, when you're arguing it in terms of what they call restorative justice, restorative justice focuses on repairing the harm caused by a crime, yeah? So rather than retribution, it encourages dialogue between individuals or victims and the offenders and aims to address the moral and ethical dimensions of harm and even reconciliation. Not so. Now, if you're arguing it in terms of what they call cultural and religious perspectives, then you want to understand that different cultures and religions have actually diverse views on murder. So, so some may actually emphasize forgiveness, while others may actually impose strict punishment for murder as dictated by religious or even cultural beliefs. And we're arguing it in terms of the value of life, we have to be very considerate to the fact that considerations of the intrinsic value of life are actually central to the moral assessment of murder. So ethical debates are often revolve around how much weight should actually be placed on preserving life versus the other moral principles. Listen, when you're older, you're going to be impressed by the beautiful cases that I'm going to discuss for you. Now, in terms of definitions, legal definitions and ambiguities, the moral assessment of murder can actually be influenced by how the law defines and categorizes it. And in terms of its legal distinctions, such as degree of murder and even manslaughter, can actually affect the moral judgment surrounding a particular case. Yeah, in America we have first degree, second degree, and stuff like that. In Uganda it's another case. It's only probably murder and manslaughter. Now, in terms of life imprisonment versus death penalty, the choice between life and death penalty in addressing murder raises ethical questions about the right of life, yeah, and the prevention of future harm and the possibility of wrongful conviction. And then if you can argue it in terms of public opinion versus moral values, then we can argue that public opinion and prevailing moral values in society can actually influence the legal and the moral responses to murder. So the dynamic relationship between public sentiments and ethical consideration becomes an important aspect of this discussion. Yeah? Okay, let's proceed. Now, I know I have a lot of reference and I'm getting most of my information from my book, Freedom Through the Law, Find It. Now, we are also arguing that the moral side of murder is an intricate and multifaceted topic, as I said, encompassing ethical, cultural, and even legal perspectives. So these aspects highlight the complexity of the moral judgments and the ongoing debates around the ethics of homicide, for example, and the responses to it. You can find more details in our book called Freedom Through the Law. Find it at lubogo.org or SUIGENERISLawApp.com. I'm going to give you a classic example of perhaps an example that we use in philosophy, but also in psychology, but also in law. Listen, it's called the trolley problem. Now, the trolley problem is a classical thought experiment in the field of ethics and moral philosophy. Yeah, it poses a moral dilemma and asks individuals to make difficult ethical choices. And I'm going to give you some scenarios. Okay, and the scenarios typically goes as follows. Listen very attentively. Scenario number one. Now, imagine that you're standing next to a set of train tracks, yeah, and you see an out of control trolley, hurtling down the tracks towards 5 people who are tied up and unable to move. They will almost certainly be killed if the trolley continues on its current path, yeah? However, if there is a lever within your reach, you can switch the trolley onto another track and you pull the lever. The trolley will be diverted onto a different track. But there is one person tied up on the track and they will be killed instead. That's the dilemma. How do you approach such an issue? Yeah? Now, the central dilemma of the trolley problem is whether you should actually actively intervene by pulling the lever to save lives, or the 5 lives, at the cost of 1, or whether you should actually refrain from acting and let the trolley be, proceed on its course, leading to the death of the 5 individuals. Yeah? What is your choice? What would be your answer? Listen, the trolley problem serves as a thought experiment to explore what they call ethical theories and principles, such as utilitarianism. And that's why I'm making my argument. Now, you should choose the option, perhaps, that minimizes overall happiness. Yeah? In terms of minimizing the number of deaths, which would actually typically involve pulling the lever to save the other 5, even if it means sacrificing the 1. Is that right? Now, if you're arguing in terms of what they call deontological ethics, then does the duty not to intentionally harm others outweigh the consequences? In this case, refraining from actively causing harm by not pulling the lever. Yeah. How about if you argue it in terms of what they call consequences versus intentions? Now, the problem obviously raises questions about whether the morality of an action should be based on its consequences or the intentions behind it. Welcome to How to Get Away with Murder. Listen, if you're arguing in terms of moral dilemmas, the trolley problem reflects real-world moral dilemmas where individuals must actually make difficult choices that involve trade-offs between competing moral values. Yeah? Now, the trolley problem has various variations and has actually been widely discussed and even debated in theory, philosophy and ethics. And it raises fundamental questions about moral decision-making and the role of intention and the principle of greater good. So it continues to be a valuable tool for exploring ethical theories and even complexities of moral reasoning. I'm going to give you example number 2, which still has to do with the trolley problem. Listen, how to get away with murder in terms of jurisprudence. Listen, now the scenario that I'm about to describe again is a classical ethical thought experiment in which one must make a moral decision regarding the outcome of the trolley oil pram. And here is the scenario. Scenario number 2. Now imagine you are a driver of a trolley car, yeah? And the trolley is out of control and is headed towards 5 people who are tied up and again unable to move. And you are faced with 2 options. Option number 1, you can do nothing and the trolley will hit and kill the 5 people tied on the truck. Option number 2, you can divert the trolley onto another truck where there's 1 person tied up, and in this case the trolley will hit and kill that other person. Yeah, almost similar to the first situation that I gave you. But I want to argue it in terms of explanation this time. Yeah? Now listen very attentively. Now, in this scenario, the moral dilemma, because now we're arguing in terms of the moral dilemma. Remember, the moral dilemma revolves around the principle of utilitarianism versus the principle of deontological ethics. Yes? Those of you who are doing jurisprudence, you will probably comprehend what I'm talking about. When you're arguing in terms of utilitarianism, a utilitarian perspective would actually suggest the morality right action as to minimize, as I said, the harm and maximize the overall well-being. So in this context, choosing option 2 to divert the trolley in terms of sacrificing 1 person to save the 5 aligns with what they call utilitarian principle. So the rationale here is that the choice results in the greatest overall good, saving the not total of 5 lives. Yeah? Listen, and if you're arguing in terms of deontological ethics, from a deontological perspective, some might argue that intentionally causing harm, even to save more lives, is a moral wrong. So this viewpoint prioritizes the principle of do no harm, thus allowing the trolley to continue on its path without intervention might actually be seen as the morally correct choice, as if it avoids directly causing harm to anyone. Yeah? Again, I'll super emphasize that this trolley problem illustrates the ethical tension between these 2 principles. It forces individuals to weigh consequences of their actions against the moral duty to avoid causing harm. So there is a universal accepted answer, as ethical perspectives may differ from one person to another. It serves as a thought-provoking example, as I said, on how ethical decisions can actually be challenging when choices involve life or death. I'm going to give you a good example. Issue 3. what I call issue 3 of the trolley problem. Yeah? Listen, here I'm describing another variation of the trolley problem, often referred to as the fat man or the fat villain scenario. Yeah? In this scenario, you must make a moral decision regarding the potential harm to an individual to save the lives of others. And here is the scenario. Listen very attentively. Now, imagine you are the driver of a car, yeah, that has actually lost its brakes and is speeding towards 5 people tied up on the road, yeah, and you're about to hit them, and there is no way to stop the car. However, next to you, there's a large and heavy man referred to as a fat man who could stop the car by pushing him off the bridge in front of the car. But in doing so, you'd save the lives of the 5 people tied up on the road. What options do you have? Okay, we're going to argue in terms of what we call justification of these options. Now, listen. In aspect number 1, by not pushing the fat man, if you're arguing from a deontological perspective, the act of pushing the fat man off the bridge is morally wrong, not so. So this perspective emphasizes the principles like do not harm, and suggests that actively causing harm to another person, even if to save more lives, is morally unacceptable. Yeah? Listen, on the other hand, pushing the fat man, some might argue that from the utilitarian perspective, that the morality right, in terms of the moral right, okay, is to maximize the overall well-being, which is in this context would be achieved by actually saving the lives of the 5 people. Pushing the fat man would align with this principle, as it results in what they call greater good, saving the net total of the 4 lives. Yeah? So, as I said, the fat man scenario again presents an ethical dilemma where consequences of an action conflict with the moral duty to avoid causing harm. So much like the original trolley problem, there is no universal accepted answer. The people's ethical viewpoints may actually differ. This scenario obviously will simply serve or serves as a philosophical exercise in grappling with the complex moral choices, often emphasizing the tension between deontological and Unitarian ethical principles. Yeah, I'm going to give you another one. Consider this as issue number 4, again, of the trolley problem. Listen very attentively. Now, in this scenario, you are faced with a moral dilemma again, involving a choice between causing harm to one person, again to save the lives of other 5 people. And here is the scenario. Yeah? You are the driver of a car that has actually lost its brakes. Okay? We're arguing it in terms of moral, remember that. And it's speeding towards 5 people tied up on the road and you're about to hit them. And there's no way to stop the car. However, next to you, there's a large and heavy man, again referred to as the fat man, who could not stop the car if you push him off the bridge, okay, in front of the car. And in doing so, you'd actually stop the lives of the 5 people tied up on the road. But by pushing the fat man would definitely result into his death. If you're arguing it in terms of moral perspective, listen very attentively. We have what we call some kind of justification of options. Now, number 1, by not pushing the fat man from a deontological perspective, not pushing the fat man off the bridge aligns with the principle of, again, do not harm. So this perspective would suggest that actively causing the man, causing harm to another person, even to save more lives, is morally unacceptable. We're having great discussion. Listen, now on the other hand, pushing the fat man from a Unitarian perspective, the morality right of action is to maximize the overall being. So pushing the fat man would align with this principle. It results in the greater overall good by saving the lives of 5 people, even if the cost of 1 life is involved. So the question is, the moral dilemma presented again in this scenario revolves around the tension between the moral duty to avoid causing harm and the consequences of one's action. It definitely will help us reflect what I call classical philosophical questions that continue to provoke the debate in terms of our discussion. So as I said, there will not be no universal accepted answer, as people's ethical viewpoints may actually differ based on their emphasis in terms of what they call deontological or Unitarian principles. Yeah? I'm going to give you another scenario. In this scenario, you'll be presented with a doctor facing challenges of what they call moral dilemma involving the allocation of limited resources, yeah, and the decision of whom to save in a medical emergency. And here is the scenario. Listen very attentively. Now, here, the doctor is in a situation where they have the capacity to save one person's life among several patients, yeah? And they have 5 patients with relatively minor injuries. One patient is on the verge of death and requires immediate intervention to survive. What would be your redress? Listen, in terms of resolution and justification, the ethical principle guiding this scenario is often referred to as what they call the principle of triaging, yeah? The principle of triaging, or what they call triage ethics, which is extremely applied in medical emergencies and disaster situations. So triage basically involves assessing and prioritizing patients based on the severity of their condition and available resources. So here is how probably the doctor may react in terms of resolving the situation. Option number 1 is to take what they call immediate action. The doctor's primary duty is to provide medical care that maximizes the overall benefit to save as many lives as possible. Yeah? Option number 2 is to assess the severity. Yeah? The doctor should actually assess the patient's conditions and determine the severity of injuries. In this case, the patient on the verge of death is probably the most critical condition. Yeah? And then option number 3 is what they call the triage decision. Given the severity of the situation, the doctor should prioritize the patient who is on the verge of death for immediate medical intervention. The decision is made to maximize the likelihood of saving at least one life. Yeah? And then the aspect of treating of others, another option. Of course, after stabilizing the patients in critical condition, the doctor can then attend to the patients with minor injuries. Yeah? The goal is to provide care for everyone, but it must be done in prioritized manner based on medical urgency. Listen, as I'm arguing here, please understand that the ethic basis for this approach is to ensure that medical resources are allocated efficiently to save lives, probably as many lives as possible. So while it may be emotionally difficult to prioritize one's patient over the other, the doctor's responsibility is to make decisions that are in the best interest of the whole patient, in terms of their well-being, in terms of their survival. So in medical practice, such ethical dilemmas are addressed through established guidelines and the principles of what they call triage. Yeah, that is important for you. Listen, we're still continuing with how to get away with murder using utilitarianism, as I just made the point. Now, option number 7 as an example, still using the trolley problem. The scenario here would involve deeply ethical and moral dilemmas. Yeah, it touches upon the principle of medical ethics, autonomy, and the value of human life. I'm going to outline the scenario for you. Yeah, so as a doctor, listen, you have 2 options. Yes, in one room there are 5 people who are in critical need of organ transplants to survive. Yeah, and in the next room there are healthy individuals taking a nap. Yeah, an individual who's actually taking a nap, sleeping. Yeah. So in terms of resolution and justification, what options do you have? So in this scenario, we are presenting an ethical conflict that should actually be addressed from a perspective consistent with medical ethics and moral principles. Please understand that. So I'm going to lay it down for you. Number 1, there's what they call autonomy and consent. Now, the principle in terms of patient autonomy is central to medical ethics. What does that mean? It means it upholds the idea that individuals have a right to make decisions about their own bodies, including the donation of organs. So in the scenario that I have presented, the person taking a nap in the next room is presumably unaware of the situation. Not so. Yeah? And then there's an aspect 2, which has to do with informed consent, which we argue in terms of organ donation. In terms of organ donation, it must be based on informed and voluntary consent. So without the individual's explicit consent to donate their organs, it would be ethically and legally impermissible to remove their organs. Not so. Yeah? Still continuing, right? Now there's what they call beneficence and non-maleficence. So the medical ethics emphasize the principles of beneficence, doing good, and non-maleficence, doing no harm. Removing organs from a healthy individual without their informed consent would actually violate both these principles. Yeah? Now, in terms of other options, this is what we call consider other alternatives or consideration of other alternatives. So in this situation, Where there is a need for organ transplants, medical professionals should actually explore what they call ethical alternatives, such as organ donations from willing and consenting individuals, or the organ procurement process, which relies on voluntary donors. Yes, and that's something that is important, again, to consider. And then we can also talk about seeking consent, obviously. So, for example, if the person is napping and is willing to become an organ donor and consent is provided, then a doctor can actually proceed with the organ procurement. However, this must be based on voluntary, informed, and ethical consent, as I say. So, to sum, what we are saying, in absence of informed and voluntary consent from the healthy individual to donate their organs, it is ethically and legally unacceptable to remove their organs. So the principle of patient autonomy, aspects in terms of informed consent, aspects in terms of ethical obligations to do no harm must be held in medical practice. So addressing the need for organ transplant should actually be done through establishing ethical, legal processes that actually prioritize voluntary organ donations and the welfare of all the parties involved. My friend, we're talking about jurisprudence here, and I know that many people are not very comfortable with jurisprudence. But let's talk about what they call consequentialist in terms of moral reasoning. Now, consequential moral reasoning, also known as consequentialism, is an ethical theory that evaluates the morality of an action based on its consequences. Now, it points that the rightness or even the wrongness of an action is determined by the overall outcome it produces. One of the well-known forms of consequentialism is utilitarianism, as I've just been mentioning, which suggests that the morality right action is the one that maximizes the overall happiness or minimizes suffering. How to get away with murder using utilitarianism. So in terms of discussion of consequentialism as a moral reason, it's important to understand the principles, the strength, and the criticism. Now, if you're arguing in terms of key principles of consequentialism as moral reasoning, please understand the following. Consequentialism focuses on outcomes. Consequentialism places primary emphasis on outcomes of actions. It evaluates the moral worth of an action by assessing the resulting consequences. Number two, consequentialism also helps in maximizing good or minimizing harm. Consequentialism aims at maximizing the overall good in terms of the well-being, in terms of happiness, or any positive value, or in terms of minimizing harm, suffering, or negative value. Then there's what you call calculating net utility. In utilitarianism, actions are evaluated by the ability to maximize utility, which is often measured by the net sum of happiness and suffering. And then also there's what you call universal applicability. Consequentialist principles are often considered universal and applicable to all situations. So what is considered good or valuable can actually vary but remains consistent within the theory's framework. Now, if you're going to argue in terms of the strength of consequentialist moral reasoning, please understand the following. We're going to talk about the strength of consequentialist moral reasoning. Number one, it emphasizes clarity and simplicity. So consequentialism offers a straightforward approach to moral decision making, focusing on the tangible action or outcomes of the actions. Number two, it is objective and measurable. Consequences can actually be objectively measured, making it easier to compare and even evaluate the causes of action. Number three, it helps what they call promotion of general welfare. Now, consequentialism aims to promote the greatest good for the greatest number, which can contribute to social welfare and well-being of society as a whole. Now, if we're to argue in terms of the criticism of consequentialism as far as moral reasoning is concerned, then please take note of the following. Number one, is what they call moral myopia. Critics argue that consequentialism can sometimes be morally myopic, as it may overlook the right and dignity of individuals in the pursuit of the collective good. Number two, it has problems of measuring utility. So quantifying utility or well-being is a quite challenging factor. It varies from person to person and can be influenced by numerous factors. So this can lead to difficulties in determining the best course of what? The best course of action. Number three is what we call justice and right. Consequentialism can actually sometimes conflict with the principles of justice and individual rights. It may justify actions that violate the rights of minority groups in the pursuit of the overall happiness. And then Another one is what they call predictability, or what they call pre-commitment. So critics argue that strict focus on consequentialism might actually require individuals to predict future outcomes accurately. Additionally, pre-committing to consequentialist principle may actually limit individual autonomy. Okay? And then another one you could look at is what they call severity of the consequences. Some people argue that consequentialism does not adequately account for the varying severity of the consequences. For example, it may treat minor unfair and severe harms or benefits as equivalent, even if net utility is actually the same. And then another important aspect also to argue would also be in terms of complexity of decision making, where we're arguing that in real world situations, it often involves complex and uncertain consequences, making it challenging to apply consequentialist in terms of reasoning as far as practice is concerned. So, by way of conclusion, someone can argue that consequentialist moral reasoning, including utilitarianism, offers a clear and measurable approach in terms of ethics by focusing on outcomes. While it has strength in promoting the overall being and simplicity, it faces criticisms related to individual rights, to justice, and complexity of real-world, decision making. It's essential, my friends, to consider these strengths and limitations when applying consequentialism to ethical dilemmas and to balance it with other ethical theories when necessary. Yeah? So please understand also that categorical moral reasoning and consequential moral reasoning are two distinct approaches in as far as ethics is concerned, and they can be applied within the framework of jurisprudence, which is the study in terms of interpretation of law. Yeah? So we're going to explore aspects that have to do with how these apply in the legal and ethical context. Right. How to get away with murder using utilitarianism. Yeah? Now, in terms of what they call categorical moral reasoning, please understand this. Categorical moral reasoning often associates with deontological ethics. In other words, it's based on the idea that there are moral principles or duties that should actually be followed, regardless of the consequences. So it emphasizes the inherent rightness or wrongness of actions themselves. I'll give an example. An example is, consider a case of free speech. Yeah? From a categorical moral reasoning perspective, one might argue that individuals have a moral duty to protect and uphold a right to free speech, regardless of the specific consequences of that speech. Yeah? This means that even if by allowing certain forms of speech may actually lead to negative outcomes, so the principle of free speech remains an ethical what? An ethical duty. Yeah? Let's continue. We could also look at it in terms of what they call consequential moral reasoning. Yeah? If you're arguing in terms of consequential moral reasoning, then you would understand that consequential moral reasoning, often associated with Unitarianism, its intention is to evaluate the morality of an action based on the consequences it produces. Now, it emphasizes maximizing, as I told you, in terms of overall well-being or minimizing harm. Yeah? And I'm going to give an example. Now, when you're arguing in terms of legal context, consider sentencing guidelines, for example, for criminal offenses. Jurisprudence may actually involve weighing the consequences of different sentencing options. For instance, a judge, might consider the consequences of imprisoning a non-violent offender, such as, the potential harm to their family or employment or reintegration into society. Now, from a consequential perspective, the goal is to choose the sentence that actually maximizes the overall well-being or minimizes harm, which may lead to alternative sentencing options such as probation or even community service. Yeah? Now, if we're going to argue in terms of application in jurisprudence, please understand this. Categorical reasoning, as far as jurisprudence is concerned, please understand that in the realm of constitutional law, for example, judges may actually apply categorical reasoning when interpreting fundamental rights, such as the right to privacy. And they might argue that the right to privacy is a categorical imperative, and the government should not infringe upon it, regardless of the potential consequences of not doing so. Yes? Now, if you look at it in terms of criminal law often involves categorical reasoning when it comes to, for example, to the prohibition of cruel and unusual punishment. Courts must determine whether a particular punishment violates this categorical moral prohibition. Yeah? Now, let's talk about aspects and as far as consequential reasoning again in jurisprudence. In terms of environmental law, for example, judges may, for example, apply consequential reasoning when evaluating environmental impacts on certain activities or even policies, you know. So the goal is to assess the potential harm to the environment and the long-term consequences of, you know, regulatory approaches. So if you look at it in terms of contract law, for example, judges may actually consider consequences of enforcing or even not enforcing a contract. The goal is to ensure fairness and maximize the overall societal well-being. Please understand that it is important to note that jurisprudence often incorporates, as I said, a combination of both categorical and consequential reasoning. So as legal decision making involves usually a complex interplay of principles. It involves statutes, it involves precedents, it involves what they call ethical considerations. So judges and legal scholars usually draw from various ethical theories, including deontological and Unitarian perspectives, to make well-informed decisions, just decisions. So as far as our topic is concerned, I want us to argue in terms of what we call the proponents. And some of the leading proponents of these schools of ethical thoughts, what we call categorical, deontological, and consequentialists, have actually made significant contributions in the field of ethics. And we're going to argue some of the notable figures associated with each. Yeah? If you're looking at categorical deontological ethics, then you may want to argue in terms of a gentleman called Immanuel Kant. He's referred to usually from 1724 to 1804. Kant is one of the most influential figures in deontological ethics. His moral philosophy is often referred to as Kantian ethics. He argued that moral principles should actually be based on reason and rationality, not just the consequences of action. In fact, Kant's categorical imperative is a foundation concept in deontology, emphasizing the importance of moral duties that applies universally and even unconditionally. Yeah? Another guy is what they call John Rawls. John Rawls is from 1921 to 2002. Rawls was a modern philosopher who actually contributed significantly to deontological ethics, particularly in the context of political philosophy. His work, which is referred to as the theory of justice, introduced the concept of original position and the veil of ignorance to determine principles of justice, emphasizing fairness and also equality. Yeah? Then if you're arguing in terms of consequentialist ethics, you may want to look at people like Jeremy Bentham, yeah? And this one is from 1748 to 1832. Bentham was actually an early proponent of utilitarianism, a consequentialist ethical theory. He argued that moral value of action should actually be assessed based on the principle of the greatest happiness for the greatest number. So Bentham's utilitarian framework has actually had profound impact on ethics and jurisprudence, and that's what we're trying to argue majorly today. And another gentleman called John Stuart Mills. John Stuart Mills, 1806 to 1873. Mills basically expanded upon Bentham's Unitarianism and often regarded as one of the leading proponents in this consequential ethical theory. He refined the concept of utility, emphasizing that action should actually promote the greatest well-being and that higher pleasures such as intellectual and moral pleasures should be prioritized over lower pleasures. Yeah? So, again, I would emphasize that it is important to note that these figures represent foundational thinkers in the respective ethical schools, and their ideas have actually shaped the broader field of ethics and continue to influence contemporary discussions on moral philosophy, ethics, and jurisprudence, and the idea of how to get away with murder, as we are discussing today. Yeah? Now, let's talk about something about the idea of what they call the familiar turning strange. Yeah? The familiar turning strange. In the context of moral and political theories, often basically this relates to the concept of moral dilemmas, yeah? And it shifts in what they call societal norms or unforeseen consequences of policies and action. So this transformation can actually challenge in terms of established ethics or even political frameworks. I'm going to give you some examples as far as that is concerned. Number one, we'll argue in terms of what they call the familiar, in terms of a right to privacy that turns strange, yeah? In this context, the right to privacy becomes a familiar concept in many democratic societies. It's considered a fundamental human right. Now, if you're arguing in terms of strange transformation, then the emergence of what they call advanced, for example, surveillance technologies or even data mining and concerns about online privacy have transformed the familiar notion of privacy into something strange. Yeah? People now grapple with the extent to which their privacy is actually being eroded in the digital age. Not so. If you're arguing in terms of moral and political implications, then moral and political theories need to adapt and address these emerging challenges of individual privacy. Yeah. So the tension between privacy and security are well, regarded debates today in terms about digital surveillance, say even about data protection that require re-evaluation of these traditional principles. Yeah. Now, if we're to argue in terms of familiar as far as free speech turns to strange, we need to look at it in terms of context. When argued in terms of context, then you have to understand that freedom of speech is a fundamental democratic value with legal protections in many nations, yeah, including Uganda. Now, in terms of the strange transformation, these rise, for example, of what they call online hate speech, for example, disinformation, cyber threats, the threat, the spread of extremist ideologies has turned the familiar concept of free speech into a source of moral and even political concern. Balancing free speech with the need to combat harmful or even dangerous content has actually become extremely challenging. Okay. Now, if you argue that in terms of moral and political perspective or in terms of implication, moral theories must actually grapple with the ethical dilemmas posed by the spread of what they call hate speech and even misinformation. So these political theories face questions about the limits of free speech and the role of platforms in terms of government, in terms of regulating the online content, as it were. Talk about what? Cyber crimes, as you like. Yes. And then in terms of familiar, when we talk about environmental conservation, in terms of turning strange, we contextualize the point by simply saying that environmental conservation becomes a recognized moral and even political goal in terms of emphasizing the protection of nature and the well-being of the future generations. Yeah. In terms of strange transformation, we argue in terms of saying that the consequences of climate change, for example, become more pronounced in terms of the familiar concept of environmental conservation that has taken on a new urgency. Yeah. So if you're arguing in terms of moral and political theories, we must adapt to address the ethical obligations of mitigating climate change and even protecting the environment. When you look at the moral and political implications, environmental ethics or political theories are actually challenged to incorporate what they call climate justice, yeah, sustainable development, and re-evaluation of economic and industrial systems that contribute to the environmental degradation. Yes, don't worry, we're continuing with our major topic, and I'm going to give you wonderful cases here at the end. There's a beautiful one coming up, but for now I want to argue in terms of familiar nationalism, in terms of turning strange. If you're contextualizing this, nationalism has historically been powerful in terms of what they call force in politics and identity, emphasizing love for one's nation. When you argue it in terms of strange transformation, we have to argue that recent trends towards extreme forms of nationalism, populism, and the rise of native ideologies have actually transformed the familiar concept of nationalism into something that can be seen as a source of division and conflict. Yeah? If you look at it in terms of moral and political implication, then you need to argue that political theories are required to address the consequences of what they call extreme forms of nationalism, including the impact of international cooperation, multiculturalism, and even global governance. So, my friends, these examples will definitely help you to illustrate how the familiar can actually turn strange when viewed through the lens of what they call evolving moral and political theories. So these instances, in terms of changes in technology, for example, in terms of social dynamics, for example, or even unforeseen consequences, challenge established ethics and even political frameworks. So we have necessitating what they call, it helps us necessitate what they call adaptations and again into what they call new approaches to address these emerging issues. Now, here is the icing cake. Let's talk about what they call the Mignonet case. What they call the Mignonet case. The Mignonet case, formerly known as Regina versus Dudley and Stephens, is a famous legal case that took place in 1884. Now, the case revolved around a shipwreck in South Atlantic and a lifeboat survival situation that raised complex moral, ethical, and legal questions. And we're going to try to comprehend some of the details of that case. How to get away with murder. Yeah, listen, my friend, the facts of the case. Now, the shrinking of the Magnonet, basically the case began when a yacht named Magnonet set sail from England to Sydney, yeah, in Australia. That's about in 1884. On board were actually 4 crew members, including a guy called Thomas Dudley, another one called Edwin Stephens, and then another one called Edmund Brooks, and a teenage cabin boy named Richard Parker. They got stranded at the sea, and in the middle of their voyage, the Magneted was actually struck by a storm and subsequently sank, and the crew members abandoned the ship and boarded a lifeboat. Yeah? Now, a situation arose. There was what they called lack of provisions. Now, while adrift in the lifeboat, the crew faced dire circumstances. They had limited provisions, and their supply for food and fresh water ran out quickly and desperately. And so there was a question of killing and cannibalism that came into play. So after several days without food, with Parker in a deteriorating physical condition, Dudley and Stevens made a fateful decision to kill the cabin boy. They argued that it was the only way to ensure their own survival. Yeah? So they drew lots and straw, and the short straw fell on who? On Richard Parker. So they killed him and consumed his flesh. For what? Sustenance. Yeah? As an argument of necessity. So in terms of the rescue and arrest, several days later, the survivors were actually rescued by a German ship. Upon their return to England, Dudley and Stevens were actually arrested and charged with murder. Yeah? And what happened during the legal proceedings? Now, in the trial of Dudley and Stevens took place at what they call the Exeter Assize in England. Yeah? So during the trial, the defense argued that their actions were necessitated by extreme circumstances, and they believed that they had no other options to survive. Yeah? And the prosecution, on the other hand, contended that the deliberate killing and cannibalism of Richard Parker constituted murder. These guys were saying, these are the guys, three guys had families, they had children. Parker came on reluctantly, he had no family, he was an orphan. Let's go ahead. In terms of the verdict and disputation, the jury found Dudley and Stevens guilty of murder and they were sentenced to death. So the trial judge, Sir James Stevens, upheld the jury's verdict. However, he submitted a special plea to the Home Office and the Crown King asking for the commutation of the death sentence due to the extraordinary circumstances. Ultimately, their sentences were commuted to 6 months of imprisonment. How to get away with murder? Listen, my friends, if we're arguing it in terms of Unitarianism and in terms of what we're talking about today, in terms of moral vis-a-vis ethical debate, the case basically sparked intense moral and ethical debates. And that's where I'm getting my title, by the way, How to Get Away with Murder. In terms of the case of intense moral and ethical debates, it raised questions about the moral permissibility of taking life, even in extreme circumstances, and the boundaries of necessity. And the case's moral complicity led to a discussion about the sanctity of life and the principles of morality and ethics and law. Yeah? So this Mignotet case remains, even up to today, a thought-provoking legal and ethical example, highlighting the challenges of balancing the principles of necessity, individual rights, and societal norms in situations of extreme what? Duress. In situations of extreme duress. And it has continued to subject, many academics, many philosophical inquiries, and in terms of giving different preferences for points of discussions in ethics as a question of survival in dire circumstances. Yeah? Now, if we're going to discuss this case, I want to discuss this case in the context of jurisprudence and in the principle of what they call greatest good for the greatest number. And we're going to make some hypothetical scenarios in support of our argument here. Yeah? Now, let's argue, for example, that suppose in this particular case, the lawsuit against Douglas and Stevens involved a question of public policy decision. Yeah? And in this case, it's advocating for a policy that aims to maximize the overall being and happiness of the majority of the population. Yeah? So while Douglas and Stevens, we can argue that this is policy, would actually infringe upon what they call individual rights and freedoms. Please understand that. Now, if we're going to apply the application of Unitarianism, where we're arguing that the greatest good for the greatest number, then we have to be very careful in terms of our application. Yes, in this particular case, we're arguing that the Queen, in this case, what would you call it, in Uganda or the government, might argue that the policy in question serves greater good by perhaps benefiting the larger portion of the population, which aligns itself with Unitarian principle of maximizing overall happiness and well-being. They may even assert that a policy's positive consequences, such as improved public health, education, economic stability, outweigh any potential infringement in terms of the individual right. On the other hand, Douglas and Stephen McCarthy argue that the policy violates what they call individual liberties or rights, emphasizing that the moral worth of an action should not solely be determined by the majority's well-being. They may point out, the potential harm or even loss of freedom experienced by those affected by the policy. Yeah? So, as we are arguing this in terms of our hypothetical, we could argue that this hypothetical can actually serve as the platform for debating the tension between Unitarian principles and individual rights within jurisprudence. Yeah? And it could raise the question of how to balance the greater good with the protection of individual freedoms and rights, and fundamental considerations in terms of the legal, in terms of the ethical discussions, and also the outcome that will depend on the specific arguments as evidence presented in this particular case. So as well as the interpretation, obviously, of the relevant laws and legal principles. Yes, we're continuing. Now, please understand that this particular case, the case of Dudley Stevens, also, as I said, known as the Mignotet case, is significant in terms of legal and ethical. It raises complex questions about the morality, about ethics, and about the law. As I said, it took place in 1884 and involved a shipwreck, in which 4 men, including Dudley Stevens, were actually stranded at the sea. And because of the extreme hunger and desperation, Dudley and Stevens killed and consumed the flesh of the young cabin boy, Richard Parker. And they were subsequently executed, and upon return to England, they were actually charged with murder. Now, we're going to argue that particular case now in the angle of moral perspectiveness. Yeah? From a moral standpoint, the case presents what they call a profound ethical dilemma. No doubt about that. Now, in terms of conventional moral principles, which generally uphold the sanctity of human life and prohibit the taking of innocent lives, killing another person, even in their circumstances, as I said, is considered morally wrong. So there's no escape route for that. Yeah? Now, in terms of many moral philosophies, including deontology ethics, for example, that one of what they call Kantian ethics, they emphasize the importance of duty and the inherent value of human life. So these perspectives would argue that the act of killing Richard Parker was actually morally impermissible, regardless of the extreme circumstances faced by Dudley and Stevens. Yeah? Please understand that. Now, if you're arguing it in terms of consequentialism, in terms of consequentialist perspective, a consequentialist perspective, particularly utilitarianism, would assess the morality of actions based on their outcomes. Yeah? So in the case of Dudley and Stevens, a consequentialist must actually argue that their actions should actually be judged based on the overall consequences of their actions. How to get away with murder. Please understand that we're just having intellectual and jurisprudential debates. Now, from a consequential standpoint, one might contend that the sailors were a life-threatening situation, and their actions, although morally reprehensible, could be viewed as an attempt to save their own lives. So they might argue that if they had not, for example, resorted to cannibalism, all 4 individuals would have actually perished from hunger, leading to a much more worse overall outcome. So, however, please understand that it is important to note that the application of consequentialism, as I said, can actually vary. Not all consequentialist perspectives would actually justify the killing of an innocent person, even in extreme circumstances. Understand that. If you argue in terms of legal perspective, yeah? From a legal perspective, the court in the case of Dudley and Stevens found the 2 men guilty of murder, and they were subsequently sentenced to death. So the court's decision reflected the prevailing legal norm of the time, which did not provide for necessity as a defense. So in cases of this nature, legal stance was inconsistent with the prevailing moral norms and principles of the era. So in summary, please understand that the case of Dudley and Stevens is complex and is morally challenging in terms of scenario, and raises fundamental questions about the balance between moral principles, between the law and Unitarian considerations. So the court's decision to convict the individuals of murder underscore the importance of upholding the sanctity of human life in the face of even the most extreme circumstances. Yeah? Please understand that. Are we demystifying the concept of how to get away with murder? Now, listen. As I said, in the case of Dudley versus Stevens, the defense did not use various moral and even ethical arguments in an attempt to justify their actions, which can be framed as a struggle between moral justification and consequentialism, even in the absence of the victim's consent, my friend. Think about that. Yeah? If we're arguing that in terms of moral justification, in terms of extreme circumstances, the defense argued that Dudley and Stevens were in extraordinary and in life-threatening situations. They had been stranded, at the sea without food for several days, and they were on the brink of death from starvation. So in this context, the defense contended that their actions were morally justified as an act of self-preservation. Yeah? How about if you argue in terms of the sanctity of life? The defense also invoked what they call the moral principles in terms of asserting that the decisions to sentence to life, of Richard Pecker was not taken lightly. So they argued that their choice was driven by desperate need to survive and that they deeply regretted the act. Yeah? Now, if you're arguing that in terms of necessity and moral duty, the defense emphasized that under the circumstances, they believed that they had a moral duty to preserve their own lives. Yeah? They asserted that their actions were born out of necessity, not malice. Yeah? Let's look at it in terms of consequentialism. How to get away with murder. Yeah? Now, if you're arguing in terms of consequentialism, maximizing what they call the overall good, in terms of the defense, following a consequentialist line of reasoning, suggested that their actions aimed to maximize the overall good. So they argued that if they had not resorted to cannibalism, all the 4 individuals of life would actually have been perished from hunger. So from a consequential standpoint, the decision to sacrifice one life for the potential survival of 3 others might be considered a rational choice. And then how about aspects in terms of arguing in terms of preventing further harm? The defense may also have argued that their actions were necessary to prevent further suffering, in terms of the potential loss of life due to starvation. So this aligns with the consequential perspective that emphasizes minimizing harm. Yeah? So, listen, my friends. So, despite the various moral and even consequential argument presented by the defense, the court ultimately found Dudley and Stevens guilty of murder. So the legal question reflected in terms of prevailing legal and moral norms of the time, which I said did not recognize necessity as a defense in this particular nature of the case. So again, I'll super emphasize that this case exemplifies the complex interplay between moral justification in terms of consequentialism, in terms of legal norms, and it highlights the tensions, as I said, between the sanctity of human life and the potential justifiability of actions in extreme circumstances, even, as I said, in the absence of what? Consent. So ultimately, the legal decision or the legal system in terms of decision upheld the principle that taking an innocent life, even in their situation, is morally and legally impermissible. Let's argue for the sake. Suppose there was an introduction of a lottery, like they argued, there was a lottery system in this hypothetical situation, where Dudley, in this real situation, by the way, they played, the lottery. Yeah, Dudley and Stevens. So they were stranded without food. This aspect of lottery does not necessarily make their action, morally justifiable, particularly from a deontological or duty-based ethical perspective. Let's just understand that a little bit. So if you introduce the argument of lottery, the fact that they did a dice, and it fell on what? On him. Could we argue that they could go off the hook? Suppose Dudley and Stevens and others had actually agreed to a lottery in which one of them would actually be sacrificed and consumed to sustain the lives of the remaining individuals, introduces the element of consent and seemingly fair process in terms of selecting the person to be what? Sacrificed. Yeah? Now, if we're to argue that in terms of a moral perspective, please understand, if you're arguing that in terms of a moral perspective, then you may invoke what they call deontological ethics. Yeah? From a deontological perspective, which emphasizes the moral duty to preserve human life and to avoid taking innocent lives. So the introduction of lottery does not necessarily make the act of killing and consuming one of the individuals morally justifiable. So deontological ethics would still assert that taking an innocent life is inherently wrong, even if the individuals involved consenting to the process. Yeah? Now, let's argue in terms of consent and moral boundaries. So, if you look at it in terms of consent and moral boundaries, while consent plays a crucial role in many, ethical decisions, it cannot always override what they call the core moral principles. So deontological ethics would actually contend that certain actions, such as killing an innocent person, remain impermissible, regardless of consent, because they violate fundamental and moral what? Boundaries. Yeah? So let's argue it perhaps also in terms of a consequentialist perspective. Yeah? Because here we're talking about Unitarianism. Listen, we're doing jurisprudence. How to get away with murder. That's the question that we are trying to answer today. Now, from a Unitarian perspective, the introduction of a lottery, for example, might actually be seen as an attempt to maximize the overall well-being in terms of distributing the risk of death more fairly. Yeah? So the argument would be that the potential survivor of the majority justifies the sacrifice of one individual. Not so. But please understand that Unitarianism itself is not a monolithic theory. Okay, and different interpretations must naturally lead to varying conclusions. Some Unitarians may still argue that taking an innocent life, even with consent, is morally wrong, while others might accept under extreme what? Circumstances. Now, obviously, in this particular case of Dudley and Stevens, it is important to remember that the legal, and the moral norms of the time did not recognize consent or even a lottery system as justifying the taking of an innocent life. They were found guilty of murder and definitely sentenced to what? Accordingly. Please understand that. Now, there's no doubt, as I said, that the case remains a compelling and controversial example of how the law and morality intersect when individuals face life-threatening situations and the ethical dilemmas that can arise in such circumstances. Sir, no, it's very important to note that the introduction of voluntary or even consent in extreme situations like the case of Dudley and Stevens would not typically be considered as a valid argument for cannibalism versus due process. So cannibalism, which involves obviously the act of consuming the flesh of another human being, is generally considered, morally and illegally impermissible. Okay, even if life-threatening situations may actually. So due process, on the other hand, is perhaps a fundamental concept in terms of the legal system that ensures individuals were afforded their legal rights and protection, including the right to fair trial and legal procedures, as I've just argued. Please understand that while the case of Dudley and Stevens presents, as I said, a unique and morally challenging scenario, it's important to recognize that it occurred within a historical and legal context that did not provide for necessity as a defense. So as an exception to the prohibition of taking innocent life, even in their circumstances, so the individuals involved no doubt were found guilty and sentenced to what? Sentenced accordingly. In terms of the modern legal systems, as well as contemporary moral and ethical norms, these generally do not condone cannibalism at all. And they also uphold the importance of due process and the rule of law, even in situations involving life-threatening circumstances. So in extreme cases, legal systems may actually consider what they call alternative defenses, such as self-defense, necessity, or the defense of others. But these defenses are typically subject to what they call strict criteria and require what they call demonstration of proportionality and immediacy. Please understand that. So we're beginning to deconceptualize or perhaps demystify the concept of how to get away with murder. Not so. Now, obviously, the question of moral permissibility versus the lack of consent in the context of lottery even procedure, as seen in the case of Dudley versus Stevens, we just argued that in terms of the complicity and the ethical challenges that are probably involved. We could go on and argue and make cases in terms of moral permissibility, for example, the aspects of consent and moral principles, and the arguments that are proponent, for example, that, if all individuals involved willingly and knowingly consent to this kind of lottery even procedure that may result in the death of one person to save the others, this could actually be morally permissible. But the moral argument here centers on the idea of what they call individual autonomy and the voluntary acceptance of a difficult choice. And then the aspect of balancing the greater good. If you're arguing in terms of balancing the greater good, from a consequentialist standpoint, the moral permissibility in this aspect may be argued based on what they call the principle of maximizing what they call overall well-being. So if the act, for example, leads to the survival of the majority and minimizes the suffering, then someone may contend that it aligns with the Unitarian approach that focuses on the greatest good for the greatest number. And again, I'll overemphasize the aspect of lack of consent, perhaps so that we can comprehend and nail down exactly what we're talking about here. If you're arguing in terms of lack of consent, then we're looking at in terms of the moral boundaries. So on the other hand, opponents may argue that regardless of consent, there are certain moral boundaries that should not be crossed, not so, such as taking an innocent life, and as I argued, deontological ethics perspectives emphasizes that some actions remain inherently wrong even if the individual willingly agrees to them. How about aspects in terms of coercion and desperation? Because someone can argue that in terms of the scenario that played out in this case, the aspect of coercion and desperation. Critics may argue that in such extreme circumstances, true informed consent may actually be difficult to obtain. Not so. The extreme desperation of individuals facing death might actually lead them to make choices that they would not have made under normal circumstances. which raises questions about the voluntariness in terms of their consent. Yeah? So those are issues that again must be also comprehended. How about aspects in terms of protection of human dignity? Yeah? In terms of moral arguments against the consent in cases like this may also emphasize the protection of what they call human dignity. Yeah? So even with consent, the act of taking an innocent life and resorting to cannibalism may actually be seen as a profound violation of human dignity and the basic moral principles. Yeah? So my friends, listen. It seems there's no excuse how to get away with murder. Yeah? And so it's important to know that the moral permissibility of such actions remains a subject of considerable debate. So it often depends on one's ethical perspective and interpretation. So in the case of that, Nevada Simmons, the prevailing legal and moral norms of the time did not recognize consent as a justifiable defense in terms of taking another innocent life, and they were therefore found guilty of murder. Again, I will emphasize that in contemporary discussions, there is no consensus on whether consent in such circumstances would actually morally justify extreme actions, and the matter is often left to complex ethical and even legal debates. Perhaps that's why we're trying to demystify the concept of how to get away with murder. My friend, it appears from the discussion that we had, there seems to be no remedy. You want murder? Get ready to be convicted. My name is Isaac Christopher Lubogo from Sui Generis Law, here